Good morning, good afternoon, and good evening to all, wherever you may be. Welcome to our panel on the WTO panel process and its future. My name is Kathleen Clausen, and I'm honored to welcome you on behalf of our co-organizers, the American Society of International Law, International Economic Law Interest Group, as well as on behalf of the Georgetown Institute of International Economic Law. We are delighted to have so many of you from all over the world joining us for today's event, including from so many backgrounds, from government, from international organizations, from the private sector, from academia, including students. Thank you for being here. I also want to thank our distinguished panel, all of our speakers, for making time in their busy schedules to be here today. I just have two notes of housekeeping. The first is to remind everyone that today we are on the record. And the second is to take advantage of the opportunity to welcome old and new friends and to remind those who are not members of the American Society of International Law that the opportunities for membership are available through asil.org, asil.org, especially the upcoming virtual annual meeting taking place at the end of March at different time zones to accommodate those of you around the world. And especially for our young professionals and students, the opportunities at asil.org as far as networking and the job board are concerned are available to you through a low cost of membership. So we hope that those of you who are not members will join asil.org when you have the opportunity. A few months ago, we might not have had such a great crowd for an event on a topic as narrow as this one, but as recent events have confirmed, it is wonderful to see such great turnout for today's event, which reminds us of the importance of both the American Society and the Georgetown Institute and the great resources that they are for us all. And with that, I'm delighted to turn the floor over to our distinguished moderator, Simon Lester.
Hello, everyone. Good to be here with you today. Thanks to the ASIL and the IIEL for hosting us, and to Kathleen for the introduction. My name is Simon Lester. I'm the Associate Director of the Center for Trade Policy Studies at the Cato Institute, and I will be the moderator for our Rethinking the WTO panel process event. Over the past several years, the hot issue in WTO dispute settlement has been the appellate body appointments crisis. Will it survive or won't it? It has been a gripping, if frustrating, saga, one that I'm looking forward to seeing resolved, fingers crossed for that. Now, whenever there's a crisis, you hear the saying, never let a good crisis go to waste. Perhaps then the international economic law and broader international law communities can try to make use of the appellate body crisis to think about how to improve the adjudication process in international economic law agreements in general and the WTO in particular. Government's efforts to reform the DSU failed by the early 2000s, but with the current crisis and so much up in the air, everyone now has a chance to weigh in with suggestions and ideas. And our small contribution to that effort today focuses on the WTO panel process. Regardless of the state of appeals and the void where they all sit, WTO panels have continued to crank out their reports, even in the midst of a pandemic that has made travel to Geneva very difficult. Perhaps because there were fewer and fewer appellate body reports to read, and now none at all, commentators have started looking more closely at the panel process. And two common things that people have pointed out are that one, the panel process takes too long to complete, and two, panel reports are often lengthy and hard to read. Now, in terms of the time frames, DSU Article 12.9 says, in no case should the period from the establishment of the panel to the circulation of the report to the members exceed 9 months. I know that's just a should, but still, in practice these days, for the period from the establishment of the panel to circulation of the report, even 1 year is extremely rare. I only see one case since 2011 where a panel was able to complete the report in 1 year. 2 years is somewhat common, and 3 or more years is not unheard of. And with the number of claims in each case growing and panels now having to deal with a large body of jurisprudence, the reports are often, although not always, because I've seen a few short ones recently, often quite long. We have assembled here a great group of speakers today to look at these and various related issues in the WTO panel process. Regardless of whether the appeal process can be fixed, and again, I hope that it will be, we want the panel process to work better than it has. So we're going to start out with Joost Pauwelen, law professor at the Graduate Institute, former WTO Secretariat staffer, one of the arbitrators on the MPIA, the alternative appeals mechanism that we may have to use if we can't bring the appellate body back, who will elaborate on some suggestions he recently made relating to improvements in the WTO panel process. We'll then turn to Kola Fagelo-Kugler, who is counsel at the Advisory Center on WTO Law and has litigated many WTO cases for her perspective. Then we'll hear from Johan Human, former director of the WTO's Rules Division, which handles the WTO's trade remedy disputes. He was previously head of the South African Trade Remedies Authority and has been a WTO panelist on a number of cases. And after these three speakers, we'll then hear comments and reactions from first Jean-Yves Remy, formerly a lawyer with the Appellate Body Secretariat, now Deputy Director of the Sridhar Ramphal Center for International Trade Law Policy and Services at the University of the West Indies, a nice place to hang out during a pandemic. And she's also been a WTO panelist herself. And then finally, we'll hear from Ignacio Garcia Bercero, Acting Director for Multilateral Affairs at the European Commission, in charge of WTO issues there. And then we have an hour and a half total, so we should have time for some discussion and some Q&A from the audience. So with that, let me turn it over to Joost now for his opening remarks.
Okay. Thanks, Simon. I hope you can all hear me. Yes. Excellent. Thanks also to the organizers for having me. It's quite something what a tweet can bring about. I tweeted about this issue of how long it takes to complete a panel process, and that resulted in this event. So I'm really curious to see what people have to say. Now, in my opening remarks, I'll keep it simple, short. I want to do three things. One is to remind everyone of some basic facts. Secondly, to explain why timing, because that's what I want to focus on, the length of panel proceedings, why timing and keeping it short is so incredibly important for the WTO system, way more important than for other legal systems. And then finally, I'll just briefly run you through the 10 practical suggestions that I tweeted out. And given the limits of Twitter, that will be very to the point. Now, first of all, on the facts. So imagine you're working for a law firm or government and you are thinking of filing a WTO dispute. Now, under business as usual, and assuming even the appellate body is back, but it follows business as usual timelines, the reality is, the fact is that on average, you'll have to wait 2 to 3 years for an outcome on your claim. And here I'm thinking of by the time you get a panel to come with a ruling, and then in 70% of cases, panels are appealed. 2 to 3 years. Now, if you want to think about when will you be able to retaliate if a breach is found and no compliance results, or when can you rationally expect the loser to comply, then you have to think realistically about 5+ years. I repeat, 5 years it will take, because we have to add to the panel the appeal process, a reasonable period of time to implement, which is normally a year, a compliance panel proceeding, which has also gone completely out of hand in terms of time limits, and then an arbitration process on the right to retaliate. Now picture this, 5+ years. And these 5 years come completely free to the defendant, which means during those 5 years, you don't have to worry about compensation, damages, because the remedy in the system is purely prospective. Okay. Now, that means in practice that most potential claimants won't even bother, or will have a very small set of cases that are actually filed. Not because there's not many breaches out there, but because of the nature of the system and how long it takes. So you'll have to have either very deep pockets to go through these 5 years of litigation, and or to have a real systemic case. Now, I came up with my tweet in the early stages of the pandemic, thinking about, oh my God, to have a panel or a WTO case for anything related to a crisis or a pandemic, forget about it. 5+ years. Now, final fact, and Simon mentioned it briefly, it's not as if this is just getting out of hand because there were no time limits, as in investor-state arbitration, where in most cases, you don't have time limits. There's very strict time limits imposed. It should, in no case, that's pretty compelling to me, take more than 9 months, 270 days between establishment and circulation. On Simon's website, worldtradelaw.net, the average that he puts out there is exactly double that number of days. So instead of 270, it's 540. Look at compliance panels. There the rule is a shall obligation, shall not take more than 90 days. The average on Simon's website is 400 days. So we've doubled the amount, or in terms of compliance panels, quadrupled the amount of days it now takes. Now, let me quickly go to my second point, which is, why is timing so important in this WTO system? Whenever I raise it often, people will say, well, but in my domestic courts, it takes 6 years or 7 years. Or look at the International Court of Justice, where it may take many, many years as well. Now, very importantly, those legal regimes are very different from how the WTO works. First of all, and I've already mentioned it, the remedy in the WTO is purely prospective. And most other legal systems, as you wait for these 5 years, you'll get compensation down the road, or you'll be receiving damages for the harm you suffered during those 5 years. Not so in the WTO. Now, why is this so? It's by design. Because the WTO system is a suspension, a retaliation system. It's not an enforcement or a traditional legal system. Now, what do I mean with this? Trade agreements, and not just the WTO, but trade agreements are balance of concessions. And then if you deviate and a breach is found, you, as the victim of that deviation, you have the right to retaliate to an equivalent amount. That's how it works. Breach, suspension, in return, hopefully compliance. It's very different from a police or a compliance system where you have a kind of a police power in place and you have suits to achieve compliance and compensation for harm done. Actually, if you look at the WTO system, it's a system that is there, the dispute settlement system, to limit and cap retaliation. To limit and cap retaliation, not to beef up enforcement. So what the system is meant to do is decide on breach, authorize retaliation, make sure that the retaliation is equivalent. So the point of comparison is not the International Court of Justice or Belgian, Italian, or Indian courts. The point of comparison is unilateral retaliation. It's basically Section 301 of the US trade laws, or how long it takes for a country to detect breach and then retaliate in response. And as you can imagine, unilateral retaliation normally can be done in a matter of months, not years. So I'm not saying this is optimal, that's how I would have designed the system, but the DSU was a bargain whereby you get quick multilateral determinations of breach and retaliation. And in particular, the US had to give up unilateral sanctions. So the goal of the system is to avoid escalating trade wars. You cap retaliation. And as we all know, in the last couple of years, the system has really failed because we have seen trade wars, or at least alleged breaches and then very quick retaliations that escalated. Think of the US steel duties that were imposed, it's now a while ago, but in March 2018, many countries were affected by these US steel duties. The question is, how do you respond to this? Now, the DSU is there to get to a quick determination, multilateral determination on breach. And then if there's no compliance that follows, the right to retaliate to an equivalent amount. Now, it's almost been 3 years since these steel duties have been enacted. So if you're the EU, China, any of these other complainants, you have to wait now for 3, 4, 5 years before you can retaliate. So the bargain in that sense has been destroyed because we no longer have quick multilateral determinations on breach and retaliation. So there's an enormous amount of pressure to fall back on unilateral retaliation. And that's honestly what these other countries have done. Of course, they've said this is a safeguard measure, we have the right to retaliate, but politically it was just impossible for many of these countries to wait for 5 years until they retaliated. So very important in the suspension model to have quick determinations. Otherwise the bargain, the pressure to go back to unilateralism will be really strong. Now, if you look at the facts that I've summarized, the system has put a premium on length, correctness, coherence, full detailed reports, and has lost sight of speed, efficiency, resolving quickly specific disputes. Now, a last point on why it is so important to have quick results in this WTO suspension model. I think 90 days for an appeal, 6 months for a panel, it's not just a time element that you can detach from how the system works or is supposed to work. As I said, the strict time limits are there for a reason, because the system replaces unilateral sanctions. So it needs quick results. Now, that time element is important also because it says something about the mandate of panels or the appellate body. If you only get 90 days or if you only get 6 months, that should tell us something about what you're supposed to do. Now, I'll turn now finally in the third step to my quick practical suggestion. So what I had tweeted was kind of an outrage about how long it takes, and then quick points. First of all, to really shorten the panel process, I think one will have to rethink who are the panelists. And I would say appoint legally skilled, time-invested panelists. Secondly, put government officials back in control, not private law firms. And I'm not saying private law firms should be banned or have no role to play. I'm just saying that private law firms should play a role, play an important role, especially for developing countries. But too often they do the entire case on their own without little control from the governments. And I think it's very important that governments who have a systemic interest in the system and how it works across cases keep in control. Third point, have only one hearing. So 2 rounds of submissions and then a hearing. That's also actually what happens in investor-state arbitration. Fourth point, prune claims to a minimum by means of a pre-hearing conference. 5, stick very closely to the timeframes in the Appendix 3 to the DSU, unless exceptionally compelling reasons, and firm up rules of procedure. I've seen a lot of cases where parties play procedural tricks, and that way you can prolong the proceedings. If rules of procedure would be clearer, I think that could be alleviated. Number 6, decide only claims key to resolve the dispute. As I said, the system is there. You need a quick yes or no on breach instead of 200 pages on 20, 30 claims. Point number 7, have the Secretariat issues paper, if you still really need one, limited to 5 pages, not 100, 200 pages that we now often see, and have panelists, not staff, draft the report, so that lack of staff can no longer be used as an excuse for delay. Point number 8, write short, clear reports without obiter dicta. But of course, for that, you need panelists with expertise. You need to prune the claims and you need to decide only on necessary claims. And then I think if you do that, you make the system accessible again to government officials, because now it has become so complicated that we really put a premium, provide a monopoly basically to highly experienced law firms or specialists. Number 9, revitalize the interim review to spur settlement and limit appeals. Interim review at this stage is basically dead. It doesn't mean anything. Instead of getting rid of it, I really think it should be revived to spur settlement and for it to act as a bumper, a limitation on appeals that may happen. Again, today there's 70% appeals rate. This is really, really high. Number 10, and that's the final practical suggestion that I mentioned, limit review on appeal so that you put panels back at the heart of the system. So get that appeal rate down from 70%, limit review on appeal. I think this is not the place where we'll talk about appeal, but we all know Article 11 claims have taken center stage, and invite parties to appeal. There's probably no need for the appellate body to redo everything in every case. And again, the statistics are telling in 85% of cases, the appellate body has reversed something or everything in a panel report. Now, the way I ended my tweet, and I will also do it here, is by highlighting that as detailed and multiple my suggestions are, almost all of this can be done without reviewing, changing the DSU, the treaty itself. This is a matter of practice, culture, process, not so much treaty provisions that would need to be changed. So that's why it's important to debate this, to discuss this, and to get all the stakeholders behind these kinds of reforms. But I'll stop here. Thank you, Simon.
Thank you, Joost. That was a great way to kick things off. A lot of thought-provoking suggestions in there. And so now let's turn it over to Kolo and see what thoughts you've provoked in her.
Thank you very much, and thank you very kindly for the invitation. As you've heard, my name is Kulafelo Kugler, and I'm a counsel at the ACWL, the Advisory Center on WTO Law. And just before I start my intervention, I'd like to make the usual disclaimer. All the views that I express in this session are made in my personal capacity, and they do not necessarily reflect the views of the organization for which I work. So my intervention in today's session will come from the perspective of developing country users of the WTO dispute settlement system, as this is what I do in my professional capacity. And although, as we all know, in the early days, the WTO dispute settlement system was dominated by developed countries, and for the largest part it still is, right? The US and the EU far surpass any other sort of next coming member in terms of the number of disputes that they've used as the main parties. But it is a system that is increasingly being used by developing countries, and just indication of what the work that I do. So since the ACWL was established in 2001, we've been involved in 20% or 1 in 5 WTO disputes. So, as a very sort of frequent user of the system and with our members, we are deeply affected by what happens. So as Joost has read, and I really thank Joost for sort of sparking this session, there are many tables on the topics on the table, and I'm sure that my co-panelists will address them very ably. But I would like to limit my intervention to about 4, and then just point out one issue that I do not agree with Joost. I will discuss panel composition, the scheduling issues with panels, the number of hearings, and cutting down and simplifying panel reports. And I will point out where I think we can save time and where I don't think it's appropriate to save time. So we've heard that there are large delays, but I think we should also admit, or I would like to admit, that in general, the panel process works pretty well. It works, it's there. And I know we have a very sort of low benchmark. The appellate body is not there. But no, I've been doing disputes for a few years, and I did some disputes in the domestic system. Yes, we cannot compare, but the panel process works. However, as previously mentioned, the point of comparison is basically the DSU. And so when you compare what the DSU says with the timelines that we see, as Simon and Joost have explained, it takes about 18 months to get a panel report. There's a lot of room for improvement. However, I do not think that the panel composition process or period is the time or the place to save time, because simply the clock starts ticking from after the panel is composed. So anything that happens before that is fair game. And I think, we shouldn't really count that time. So I think, well, I'm going to sort of modulate what I'm saying right now in a few seconds. So I think there's other places where we can save time, and I will point that out. Now, the part of panel composition that I don't think we should save time or try to cut back on is where members take their time. So I was recently involved in a panel composition process that took about 6 months. And the parties were given 7 slates of panelists to which to choose the ultimate panel. So in that regard, I would say that, 6 months is a long time. But as I said to you, that we don't start, the clock hasn't started ticking yet. So it could take as long as necessary. And I think we all should realize that this is a very sort of critical time for the parties. It's a time when parties can still settle the dispute. And as we know, settlement is what is preferred under the DSU and in the WTO system. And so why not? Let the parties take however long we want. And as we know, there is sort of a stopgap. There's recourse. If the complainant thinks that the respondent is just kicking the can down the road, the complainants can pull the plug and ask the DG to compose the panel. So for me, this is really, I think we should leave this alone to the parties. If they can settle the dispute at the time, that would be great, because trying to limit that time is unhelpful and is ultimately against what the DSU purports. But there are obviously other players and other parts in this specific process that that we can maybe help the system, and it has nothing to do with the parties. And as Joost has intimated to, is that we can definitely save time by ensuring that there's sufficient lawyers at the WTO Secretariat to staff the disputes. I remember there was a very acute shortage between 2015 and 2016, where in the dispute that I was waiting for, after the panel was composed, the parties had to wait 6 to 7 months. And this is a very long time in any process. I mean, this is basically 6 months is basically how long the panel process should take to begin with. And also, of course, for countries that don't have many resources, it could be a problem, especially when you're facing a measure that affects your market access. And so I think just generally overall, where the WTO Secretariat, or where the system, not the parties, can help the system and can be, a solution and not a problem, I really think that members should also consider, making sure that there's adequate staff lawyers to staff all disputes on time, of course. The second part where I think we can save time is scheduling the disputes themselves. As you can imagine, we have 3 panelists, and we have to manage their very busy schedules because they're not full-time professional panelists. They have their own lives and they do their own things on the side. And that obviously causes a lot of delays. And I do agree with Joost in this regard, is that the system could be very well served by having a pool of professional panelists from which to pull panelists from. And of course, as being very, as experienced professionals, the quality also of the panel reports and, the interpretation will increase. But I do not subscribe to, and as much as I am a lawyer, I do not subscribe to any suggestion or proposal that states that the panelists should be limited to lawyers alone. I think other, professionals bring much value to the dispute settlement system. Furthermore, I think that a little bit of flexibility is warranted as well, and it's needed for the system to work efficiently. Specifically, just recalling back to the time when there was acute shortage of staff lawyers, there were some suggestions from parties to change the process a bit. So to do what we call from the HARA process, the double briefing, and then have 1 hearing, or maybe even 2, depending on how it goes. I mean, this was met with a lot of opposition. Of course, the other party in the dispute probably played a role. But I think in instances when there was such huge delays before even the panel starts, the panel can use its discretion to set its working procedures as it wishes and really try to see where, time can be saved. And I think in those specific instances, it would have been warranted and accepted and reasonable for a panel to sort of pull the process a little bit tighter. I would like to also then, in those terms to flexibility, is just call upon the experience that we have, all, collectively experienced or gained through this COVID period, and really try and see where we can, as an exception, of course, because I know there are confidentiality sensitivity issues where panels or panelists can, join a panel remotely. This is possible, and we have the technology to do so. And if we can use this as sort of an alternative manner, or maybe even incorporate it in the long term. I mean, I know there are sensitivities and sensibilities, but this is an option that we can use to cut down on the time wastage. I'm just going to, I know I don't want to sort of be long there. My colleagues would also wants to say a few things, but I just want to sort of quickly state two other issues that I agree with Joost, or maybe, I don't know if he stated this clearly. Oh, yeah, he did, the hearings. So in my experience, and happened in a few panels where the first hearing is basically a meet and greet, sometimes we get advanced questions and we say, we make the opening statements and, we have lunch and then we come back from lunch and then there's a few questions asked, and really an inefficient way of spending a lot of time and a lot of resources and a lot of money, especially for countries that can, scarcely afford to fly to Geneva. And so, although I know that the members really value the two hearings and there would be a lot of backlash, I would suggest that, if not considering cutting down one hearing, but really making sure that the two hearings are warranted and needed. And if we can really consider a system where we have one hearing and maybe over sort of a longer period of time, maybe we can really save a lot of time, and not just time, of course, resources, money as well. And finally, the case for simplifying and decreasing the length of panel reports. I just read this on Twitter this morning, and somebody made a joke about how the latest request for consultations by Malaysia was 23 pages. And that's the length of some of the earliest AB reports, and that is true. I think gasoline, some early AB reports were just short and to the point and very sweet. Yes, I understand over time the disputes have increased in complexity and number of issues and everything, but it's also sort of a symptom of what's happening. Members are obviously bringing more issues to the table, and I'm sure maybe somebody in the panel will discuss this issue. But there is really a value to cutting down on the length and the complexity of panel reports, and mostly because for example, in my work, I work with developing countries, and sometimes when we do training with with investigating authorities, and they say, well, they didn't know that was the rule, and I say, well, it was in this report, and they just look at me squarely in the face and say, we don't even bother to read those panel reports because we don't understand them. And these are people that would speak English very, well, normally. It's not a language issue. It's just, just being able to understand the panel report. This, I guess, concludes my intervention. I would love to, add more points later, but I would like to leave some points for my co-panelists to address.
Thank you, Kolo. That was great. Good to get insights from somebody who's sort of an active participant in litigation. We now turn it over to Johan for his thoughts. Johan, over to you.
Thanks, Lester, and thanks for the invitation. And we've had you as the academic, and you have had an active player in the game, and now you have has-been. But the has-been saw everything. I started off as a lawyer, practicing lawyer in South Africa, joined the Department of Trade and Industry for a GATT dispute. And just to come back to Kolo's comment, the panel report was, including the descriptive part, a whole of 26 pages, double spacing, mind you. And it was quite a good report. But I've seen it from all sides as a litigant in the GATT, a representative in GATT, involved in negotiations, in disputes, joining the secretariat. Well, I did a couple of panels, some of them as chair, and then 17 years in the rules division, of which 10 years as the director. So I've seen it from all sides. So I thought what I'll do is I'll just go to the practical side. I think Joost has given us a very, very good introduction on why things have to be done speedily. And the question that I have is, why is it that things started to take more time and more time? Now, there are all kinds of reasons why the system developed the way how it did. But I'm going to make two practical proposals. I'm going to restrict myself only to the timeliness of the of the process, because at the start and after 95, the members were sort of quite happy with the process, and as time went by, they started to asking all kinds of questions, and because of the delays. Now, you have to move quick, and I agree with yours. It's not really fair to compare it to other international fora, dispute settlement fora, or even to domestic courts of law. In the GATT and in the WTO, there were balances to be struck, and the whole idea of dispute settlement was when things were negotiated to be quick, and that's why you have the limited time periods. Now, of course, in those days, things were not that complicated. Well, they were complicated, but they were a little bit more streamlined, and that is one of the issues that I want to address. Why were things a little bit more streamlined during the time of the GATT? And my conclusion is very, very simple, and that is there are just too many claims. Claimants bring a bag full of claims, and they throw everything at the panel, and then the panel will have to sort it out. And of course, that's going to take time. You also referred to some other issues which started to make them the disputes taking longer and longer. Now, in any dispute, you have a few core issues. Those are the issues that the adjudicators have to resolve to make the dispute go away. Now, of course, you can bring numerous other issues and claims, but you have to ask yourself really which are the core issues that you have to bring to a panel, taking into account the nature of your dispute settlement system. Even in a domestic court of law, and I've experience in that, if, with all due respect to the members, in the domestic courts of law, if you would approach a court with all the claims that we've seen in the WTO over the years, covering all kinds of issues and safety nets and claims put in the alternative, a judge will take a really grim view of you, and they will call you into his chambers and to tell you, okay, parties, you sort it out. You're not going to waste my time. Let's focus on those issues only on which we need to find a resolution. Nothing more, nothing less. Now, of course, members are sovereign, so they can bring the number of claims, but there should be a mechanism to reduce the number of claims. And you just referred to a sort of meeting, a pre-hearing conference. And I'm strongly supportive of an idea like that. Bring the parties together, either with a panel or with a claims ombudsman or ombudsperson, or even the Director General of the WTO, to assist the parties to reduce the number of claims. Because if you analyze it very carefully, you'll might agree with me that this is the heart of the problem, because it really has a serious domino effect on the first meeting, on the timing issues, the availability of panelists, the work of the secretariat, the report in the end. So if you can keep it short and simple at the start of the process, that will go really, really a long way. Now, you know, there's also a little bit of a domestic analogy to that. If you watch many movies, you will know that if a man and a woman, if they have a dispute, usually if it's a main issue, then things start to go a little bit haywire, because they then start to throw in all kinds of things that happened not only yesterday or the day before, but 5-10 years in the past. And that's sort of the same with the WTO dispute. Everything is put on the table. Now, most of domestic legal system have a mechanism to reduce the numbers of claim and not to overburden the adjudicating authority. And I think there's no reason why members cannot relook at this and to find a way to reduce the number of claims. And as Connor said, or you said that most of these proposals, now I don't agree with all of them, but I'm not going to go into that. We can do that when we get to the comment side. But you can find a way of implementing it, because in the end, when you really look at it, you have to be objective and fair to the negotiators of the DSU. It wasn't that bad an instrument. It started to unravel a little bit when it got to implementation, but these things unraveling took place because of certain reasons or developments, good or bad. That's not the issue. That is what we're stuck with. The second issue that I feel quite strongly about, and that is the backloading. And that touches upon the first meeting and the second meeting and the usefulness of that. What we've seen is that parties, because of the high number of claims, they're not that forthcoming in the first written submissions. So the panels then don't have a way of finding all the facts or having all the facts in front of them at the conclusion of the first meeting. Because if you look at the working procedures attached to the DSU, I think it's Annex 3, it says that the facts should be on the table at the first meeting. Now, if you don't put all the facts on the table, then it's very difficult for the panel to find its way through all the detailed facts. So I think what members should really be encouraged, or parties to disputes, to make sure that they put all the facts on the table. And linked to that is to make the first meeting more useful is perhaps for the panel to have more interaction as a panel way before the meeting, that it's not a meet and greet, as Kolo has termed it, but that you have the panel really on top of it and with questions to the parties well in advance of the first meeting. Now, I know there are practical problems and constraints, but these days with Zoom, if I can figure out how to connect on Zoom, then other panelists or panelists can do that as well. Because I said with the backloading, you find then that the rebuttal meeting, the second meeting, then becomes really an issue. And even at many second meetings, all the facts are not really on the table, or the arguments, because the DSU says that all the facts and the arguments of the party should be on the table or should be covered in the first written submission. So if you haven't done a good job there, then you make it very difficult for the panel to sort things out in good time. So what this all mean is, I'm going to be short now, is panels there should be a mechanism for panels to meet the week before, or even earlier than that, before they meet with the parties. They can do it virtually. There's no need to spend an inordinate amount of time in Geneva as panelists, because it's very difficult to find a panelist who will be able to be in Geneva for 2 weeks. Sometimes a week is quite tough for very senior people. So, but there are ways and means to do that. And what you can then do is either the first meeting can be virtual or the second meeting. I'm sort of easy on that one, but you can cut it to one meeting and one virtual meeting. Now, I'm going to stop there because I think time is running on us, because there are a number of other issues that we can discuss when we discuss US's proposals. Thanks, Lester.
Thank you, Johan. That was great. So we're now going to turn to Jean-Yves for me and Ignacio Garcia-Bracero for sort of comments on what the others said. Before we get to that, first, let me just mention, I think some of you have already noticed the Q&A icon at the bottom of the screen there. If you want to pose a question, we're not going to be able to get to them all. I see we're already kind of low on time, but if you have something you want to put out there, throw it in the Q&A and we'll see if we can get to it. So now let me turn it over to Jeannie for her thoughts on all the interesting things that have been said so far.
Thank you. And well, thank you to the organizers for allowing my perspective to be presented in this forum. And I'm looking at the participants list and seeing a lot of familiar names from my time back in Geneva. And I think Johan said that he is a has-been from the process. I think it's fair to say that my experience now is fairly wide-ranging, from both being at the Secretariat to being at a law firm and to being now a panelist. And so my perspectives, I would also put on the record, as Kolo did, are purely personal and reflect my own thoughts about how the process can be actually improved. Now, I want to interrogate a few of the premises that Yo starts with and about which his proposals seek to address. And the first one is the premise that a shorter WTO panel process is desirable, or that the membership actually thinks that it would lead to better outcomes. Now, I see the point that Jos is making, having listened to him, that there are some savings that should be encouraged in terms of time. But I think it's certainly fair to say that it all depends, right? Some cases, depending on their complexities, who the players are, whether it is an intensely factual case, whether indeed you need to accommodate different interests, may be inevitably long and entailed. Instead, for the reasons that I will kind of expand on below, I believe that a more important metric or prism against which we may judge the proposals and judge efficiency is through whether or not we are aiming and we are achieving a more legitimate process that is more expedient and efficient. Now, the question about what promotes an effective and a desirous outcome from the dispute settlement community is not, in my view, altogether clear either. And whilst Joost is prioritizing in his tweets time savings, I believe that a better sense of where the membership feels more of the reform should be taken should benefit from a similar exercise that we saw in the appellate body process, where we had a galvanized attempt to try to really fix the problems that were most impending and needed to be developed or needed to be addressed most efficiently and most importantly because of the crisis that was happening over there. So my point, I guess, is that while shortening the process certainly has a lot to commend itself, I believe that maybe a broader perspective needs to be engaged in determining whether or not this is really the thing that we should focus our attention on. And then more diversity of interest from all sorts of players in the system, from developing countries to developed ones. And I don't think we can kind of decide which takes priority by stealth and because of the ease with which they can be accomplished through working procedures, et cetera, instead of having to go to more fundamental DSU review. So that's the first kind of framing issue that I wanted to bring out. The second broad framing issue relates to the context in which we find ourselves presently. No appellate body. It's not clear to me whether the recommendations that Joost is putting forward are being envisaged against a background of the appellate body of old. So imagining a two-tier process where we're trying to fix the panel process in order to make it better suited to an appeal or make it better able to be absorbed by the appellate body, or whether we're thinking of a new panel process that will actually operate instead of the appellate body. Again, thinking seriously of these kinds of changes that we may want to see at the panel level is dependent really on whether the system we are redesigning it for is single or two-tiered. We can therefore interrogate the very premise, again, of Joost's recommendation, which is that we really want to see the panel return, he says, to the heart of the dispute settlement system. So the question really of whether we are redesigning a panel to be better suited to an appellate body or without an appellate body process is really key. But putting these kinds of issues aside and for purposes of the discussion and really focusing on what has been said and what Joost has proposed, I think we can proceed on the basis of at least a few unobjectionable assumptions about what we want to see in a new panel system. And that is one that is efficient, expedient, fair, and legitimate, whatever legitimacy means, and one that is couched within a two-tiered system. So my suggestions or my reactions are really premised on a more effective panel process that is based on the current system as designed under the DSU, which is a first stage to dispute settlement. And I'm really looking at your proposals and thinking about how I can improve them or how I can really think of ways to support them, but also think of ways of further refining them. And when I look through all of your points, what I do perceive is an attempt really to empower the panel in the process and accord panelists a greater role relative to the membership, the secretariat, and the appellate body when it existed. And what I see running consistently through Yo's proposals is a focus really, if you look at it, on the panel composition and the panel selection process. Who sits on these panels and really the desired skill set. And as I read the proposals, it's, for me, picking the right panelist is really a predicate for many of his other proposals. I have to say that in my view, and I think I share the view of most of the panelists, the focus on panel expertise and skills is paramount if a panel system that we currently have is to be made more efficient. I don't, however, share Jost's view, and I don't think this was interrogated by any of my fellow panelists, is that the panelists must have legal skills or that they must be, in a sense, retired, because this is who you will get if you really want people who are time invested in the process. I don't think that lawyers per se are necessarily exclusively, being one myself, best suited to an enhanced task that Yo's proposals would confer on them. I think rather than legal skills, I think a very experienced knowledge of the WTO and the dispute settlement system, and even the practice of judging, would enhance some of the procedural and substantive problems we find in the system. I would therefore instead focus on a desired competence of insightful experience and knowledge, not just of the subject matter of WTO law, but in addition, understanding how to manage cases and how to judge. What we would be encouraged then, I think, is judges from other areas. So maybe arbitrators, former appellate body judges, former judges in domestic contents. But while I think this skill set would actually be indispensable for each panel, I don't think each panelist has to have that skill set. There are reasons, in my experience, for favoring other sets of skills in the process of decision making. And we all know that bringing all panels to all lawyers to a process, or fully manning the panel with only lawyers, doesn't encourage brevity or efficiency, or maybe even legitimacy. So my suggestion and my recommendation sort of is a hybrid of what has been suggested, I think, by the EU, a permanent roster of panelists, and the current system where you have ad hoc selection, which I think is an adaptation of something that Simon and Jim Backus wrote in a paper. Under that proposal, each panel would be stacked by a mixture of permanents and non-permanents, with the ratio to be dependent on the competencies required in the specific case. The roster would be stacked with experienced persons with the desired skill set I mentioned above, understanding WTO law, as well as having a sense of how the process works and how to judge in the process. But selection of persons off the roster in each case, so this would be desirable based on the needs of the case, would ensure vitality, newness, diversity in the panel system. So you don't just have a permanent system that can really just become an ossified set of panelists who basically don't have new inputs from new and more diverse members of the WTO community. And I think this would also lead in some ways to cutting down on the time for selecting panelists, since at least one person on the panel would be from the pre-existing permanent roster. So as I mentioned at the beginning, and I do really focus on this part of Yo's proposal, because I think getting the right skill set on the panel unlocks many of Yo's other proposals. In particular, his recommendations for greater efficiency in the process, like the pre-conference hearings, selection of claims with the parties. I really don't think the panel should do so on its own. It should be, because then you will get greater claims lack of member control. I think a more efficient and skilled set of panels would also have less discomfort with proposing procedures where they have more control, where they can decide based on the needs of the specific case, the number of hearings that would be appropriate, maybe even imposing limits on the submission. So in other words, the basis of my proposal is really to have panels run a process, have each panel stacked with one permanent member who is very comfortable with the process and is able from that perspective to sort of work with the Secretariat and the other panelists to ensure that some of the more cumbersome aspects of the process can be reduced and mitigated. And I think that the lessons can therefore, and I think this is something that Johan said, can be learned from domestic and commercial arbitration contexts where case management is a more central feature of the process. I think in addition to enhancing the way that the cases actually proceed in terms of the management of the process, having a more professional, skilled set of panelists who are repeat players would also unlock some of his other proposals, including his suggestion that we should have issues papers that have a prescribed length, or cases that are shorter, reports that are shorter, with an increasing amount of a professionalism imbued by my proposal. I think you would not need to be so prescriptive. I think it should still be up to the panel and the chair really to decide in line with the needs of his fellow panelists what kinds of lengths they would want for the case in terms of the reports. This system would also promote consistency across reports. So the broader question of whether or not you have an appeal process that is overly burdened would actually hopefully be dealt with through a more professional process of panel making or decision making by panels. I know that I don't have much more time. What I did want to actually address in a very bespoke way is the proposal on the table that we need to kind of disincentivize or empower governments to be more involved in the process by reducing the dependence on private law firms. I think in response to that, having been in one, I think it's really a no-go because, as I think you was mentioned, a lot of developing countries in particular benefit from the advice and from the processes that a private firm can offer. And I think the case law has, for a good reason, settled this, given it the sovereigns the power to choose a private counsel. In many cases, even when government lawyers are formally litigating, they are also supported by law firms. So I think it would be very difficult in any event to enforce that kind of prescription against too heavy a participation by private law firms. If the animating factor behind the proposal is a complication of the process or delays and unduly burdening the process, I'm not sure that governments would do so any less. We have some government-based litigations that are just as complicated. And I think based on what I said before, there are certainly more direct ways to contain excesses through greater case management by judges. I'll stop here. I think there may be more questions on many more aspects of the proposal by yours, but I just wanted to end there and really say that the key, I think, to unlocking a lot of the problems that we have with the system is really, as he suggests, getting the right people on panels. Thank you.
Thank you very much, Jean-Yves. And now finally, let's turn to Ignacio Garcia-Bercero for his comments on what has been said so far.
Well, thank you very much, Lester. And let me start by thanking you and the organizers for having me here. And by starting with a very, very strong disclaimer. I think I'm the only government official present in this debate, but I'm going to be talking totally in a personal capacity. Now, I would like to start by saying that I have found the discussion extremely enriching. particularly as someone who hasn't been personally involved in dispute settlement for nearly 20 years. It is really quite refreshing to hear all of these perspectives about how the panel process could be made both more timely and more effective. Because in my view, you would really need to look into both elements when you look into what changes you want to introduce into the system. Now, I would want to, of course, be very clear. The perspective in which I'm situating myself is very much the perspective that we are going to have an effort, hopefully with a strong partnership with the United States, to find a way to restore a binding two-step dispute settlement system with an independent appellate body. But as you look into improvements of the practice of the appellate body, it would make sense to also look into improvements of the practices of panels. And quite frankly, it has been a little bit strange that all the focus of the discussion as part of the worker process was about the issue about what changes need to be introduced in the appellate body, when some of the concepts that were reflected, in my view, they're as applicable to panels. I mean, let's give you an example. I think if there's one important paradigm shift that I think is going to happen in WTO dispute settlement is the huge importance of judicial economy as something that should be a guiding principle for adjudicators to only deciding on those things that you strictly need to decide in order to find a resolution of a dispute. That's absolutely critical. And let's be honest, it's a big change in terms of the way that dispute settlement has evolved over the last 25 years. And if you look into the worker principles, that's something which is guidance which is given to the appellate body in not very clear terms, and which is not given to panels. In my view, if you are going to be looking seriously into how to change the whole approach of adjudication, this principle of a judicial economy has to be there in the center and should very much be applicable both to panels and to the appellate body. Let me give you another example, and that most people, probably everyone, would agree that there has been an abuse of the Article 11 procedure, that there have been too many cases in which the appellate body had to handle lengthy claims based on Article 11. I think that everyone would agree that it makes sense for factual determinations being properly established by panels, and only the most rare circumstances, if at all, for the appellate body to look into those determinations. And yet, if you are going to go in that direction, you really need to also think carefully about how to reinforce the capacity of panels to make proper factual determinations. Do you need to look more into the fact-finding authority of the panels? How you reinforce the expertise and capacity of panels to establish the facts of the case? So those elements, in my view, show that it is important to look into the appellate body and the panel procedure together, while at the same time maintaining a primary focus on the issues relating to the appellate body. I think that I have found many of the suggestions presented by you good ones. I don't want to pronounce myself in the technicalities because I'm not someone who has the expertise of a practitioner. I mean, some issues to save time are, I would say, no-brainers. What is the purpose of actually having the 2 DSP meetings before a panel can be established? I mean, I have heard quite a few arguments that it would probably be easier to structure the procedures if you normally only had one actual hearing, but then you actually had greater capacity at the early stage to identify which are the key issues on which the litigants should focus. All of those seem to me to be eminently practical suggestions. I have to say I'm much less convinced than you about the issue of the interim review. If anything, I would have thought, do you still need an interim review rather than can you use it in a more useful manner? I mean, it's always going to be a time between the moment that the panel report is issued to the parties and the moment when it is public, which allows the scope for settlement. I don't see that necessarily needs an interim review. But I think that the more fundamental question is that, I mean, all of those issues are issues that you can legislate. You can actually give indications about time limits. You can say that the time limits need to be strictly respected. All of that is very good. But at the end of the day, the critical thing is how you get the right panelists to serve in a panel. And that comes to the issue of panel composition. I mean, I said that I have not been involved in WTO dispute settlement for nearly 20 years, but of course my last experience when I was negotiating the DSU review and I was putting forward the European proposal for a permanent panel body, which did not get enthusiastic support by other participants in the negotiations. I'm not going to suggest that we should go back to that. I think that it is very unlikely that that would actually get the necessary support. But I think one should be looking pragmatically into ways of seeing how one could establish a roster of panelists which have expertise, which have the right qualifications, and on which parties can rely in the process of panel composition. It doesn't have to be all the 3 panelists. It can be, for instance, only the panel chair. It does not necessarily need to be agreed by all the members of the WTO. It could be agreed by the largest users of the system, but reflecting about ways of actually making sure that you have available panels which have the right expertise, who have the right practice about adjudication, who can steer the process to ensure that the facts of the case are properly established. All of those things are, in my view, useful, and one should be open-minded in reflecting how to move these things forward. Now, I would like, however, to finish with a warning as a negotiator. I think the last thing that anyone would actually want to happen in Geneva is that we just open up the second phase of the DSU negotiations. We know by experience how lengthy those negotiations were, how it was impossible to get to any conclusion by bringing in all the issues that parties could think of. And I believe that it's going to be critical that we can focus our minds and that we can focus the political energy to try to find a resolution of the current crisis of WTO dispute settlement as quickly as possible. I very much hope that there will be an active engagement by the new US administration. We know that there are some critical issues relating to the appellate body which are there on the table. They are actually reflected on the Walker principles. As I said, we should also be open to look into certain issues relating to the panel process, particularly when there's a close connection between them and those changes which will be introduced in the practice of the appellate body. But we should also be guided by the need to avoid that this becomes never-ending process of negotiation. I think the sooner that we can actually establish a situation that allows us to have, again, a properly functioning dispute settlement system, the better it would be. So I would leave it there. Thanks.
Thank you very much, Ignacio. So we are now at 10:14, and I think we have authorization to go a little bit over our allotted time. What I want to do is sort of quickly go back to the original 3 speakers, Joost and Kolo and Johan, and see if they have anything they want to say in response to the comments from Ignacio and Jean-Yves. And then I'm going to try to turn to some of the many questions from the audience. So let me first just throw things back over to Joost to see if he wants to respond to anything that's been said.
Thank you, Simon. I'd rather have us deal with questions. I think all of the reactions were very interesting. Just one point, in my proposals, I never mentioned cutting or gaining time at the panel composition stage. There I would definitely agree with Kolo. But many good points, very well taken. Thank you.
And Kolo, yeah.
No, I agree with you. I'd rather let's use the time for questions. So.
Johan, anything you want to add right now? You're on mute.
There are a number of issues that I would like to comment on, but I think for the sake of having more questions, I think I'll refrain, particularly on the issue of panel composition and the issue to find, let's say, suitable panelists, because I think that's something that needs to be unpacked a little bit, because sometimes with the length of panels was more practical issues. There were too many claims, too much work to be done, and then panel meetings had to be rescheduled at short notice, and then to find a mutual convenient time or agreeable time for all parties involved, caused huge delays. So these things all have a domino effect. But just as a broadside, I'm not convinced of a core group of permanent panelists, because you're going to run into the same problems that members have been experienced with appointments to the appellate body. But let's have questions and make it interesting.
That's a good idea. And I think I've got an interesting one here to start with. And this comes from Valerie Hughes, who asks, are there any situations or types of cases where we could have only one panelist? And this is intriguing. It's not something I've thought of before or heard suggested. But we see that with Article 21(3)(c) arbitrations. One arbitrator can handle it. And I know those are smaller cases, but maybe there are some types of cases where we could just have one panelist. And I want to put that out there to any of our panelists at this event, if they want to comment on that, if they have any thoughts on it. And I don't know, maybe you can just raise your hand. I don't think we have a procedure for this, but if anyone wants to weigh in on whether there are cases where one panelist would be appropriate and would make the process work better.
If I can weigh in on it, I mean, I think it's an interesting proposal. Presumably it's animated by a wish to kind of, limit the amount of time you spend looking for panels. One, I'm not too sure it would be permitted by the current DSU rules, but more importantly, I mean, I think a really important part of the process of decision making, and irrespective of whether this is on factual or legal issues, is that level of collegiality that you have with other persons that, and not the Secretariat who offer a vital service but they presumably, and they do not engage in decision making. And I think decision making, especially in a case where you have sovereigns involved, and where you have very, very real issues relating that could have a precedent or a precedential setting effect. I think just in terms of that process of deciding things and having a process of collegiality where you're exchanging ideas would militate against such a proposal, although I see the obvious benefits, especially in very simple cases relating to decisions on just interpretative issues. But I think it would really lead to a delegitimization of the panel process. And so I wouldn't think that would be something necessarily to be promoted as a solution.
Thank you, Johnny. If I see Johan, looks like you have your hand raised. Do you have something you want to add here?
Yes, just quickly, I agree with the comment that, and hello to Valerie, but that would be a difficult one, because it's not only the question of collegiality. What one has to keep in mind, that's something that's been sort of bothering me, or not bothering, but a little bit of a concern. You have different members with different legal cultures and approaches to the same thing. And I found it, as a former panelist, hugely educative, and you have to come to a panel meeting with a tabula rasa, a clean slate, an open mind, to listen to the other colleagues, because of just not only the factual issues and the approach, but also the legal culture of the different members, which is something which as sort of below the surface played it out in a number of cases, which can be pretty problematic.
Thank you, Johan. Does anyone else want to weigh in on that issue? It's okay. All right. I am going to turn to a question this comes from Andrew Newcomb, and I'm going to sort of build on what he says here. He asks, do we need different rules, procedures, timelines for different kinds of disputes? And he says the challenge moratorium on GMOs raises different issues than, say, dumping duties on steels. Is there a different correctness efficiency metric for different types of disputes? And just to build on that, I mean, I do think there's already a fundamental distinction between trade remedies disputes and other disputes built into the system, because we have different divisions set up for each one. So do we need to be thinking differently about trade remedies versus non-trade remedies dispute, or are there other categories of disputes where we could think about different rules and different expectations about how long the cases would take? So I'll put that out there for everybody, of course. I know that, sort of Johan, with his experience in the rules division and trade remedies might have particular thoughts on that, but really that's for all of the panelists.
I mean, my comment is just that, just thinking about trade remedies, it also depends on the dispute. So I would say maybe a safeguards case, or depending on the fact, the trade remedies case can, be quite quick sometimes, but subsidies case is not the case. So I think it's kind of difficult to maybe, conceptualize the rules in that way, in those type of categories. And then when we start getting more specific, it gets messy. So in my opinion, I would prefer sort of, rules that apply to all disputes, and then maybe flexible enough. Of course, the panel, panel working procedures would have to, the panel will have to see how complex, the dispute is, on the facts of the dispute. So I would not really think of it in that way. No, I would.
Anyone else? I'm thinking in part, one of the differences I see between trade remedies disputes and other disputes is that, trade remedies, there's sort of an underlying domestic investigation where you have a specific set of lawyers who have just far more expertise on the case than anyone else, and they can, those same lawyers can then easily move along to the WTO stage, and it seems like that puts that dispute in sort of a different situation than many others where you're starting from scratch. I don't know, this sort of ties into the role of lawyers that Joost was talking about earlier, and private lawyers versus government lawyers. So any other thoughts on trade remedies versus other disputes in all of this? Nothing. Okay, that's fine. I'll move on to another one. So let me pick up on an issue that I think was talked about a little bit, and I see in one of the questions, and also Joost and I had a brief Twitter spat about, it was friendly. But so this is the issue of the interim role of interim review. And I will say that when I read these cases, I go through all the interim review sections, and it generally seems to me like not much is being accomplished here. But I see, Gary Horlick in the question says the interim decision is useful to avoid a lot of minor errors that would otherwise require, fixing. I mean, I do see some value in that. It would look bad to have a bunch of typos in the report. I don't know, maybe Joost, could you elaborate on a bit on why you think that we could, so I think your position, Joost, is that under the GATT, the interim review was used in a way that was useful for promoting settlement. How plausible do you think it is that we could reinvigorate that? Given that it seems like, maybe we all agree we've lost that function. It's not working that way now. How would you bring that back in? How would you encourage governments to take the interim review process as an opportunity to look for settlements?
Yes, I think it sounds very technical, but it's a very important point, because I don't know of many other systems that have this interim review, which to me goes back to the idea that this system is unique and was originally very diplomatic and wants to settle a case, prefers a settlement over a ruling. And come to think of it, you have a good number of cases where the interim report came out and then the case got settled. I've worked on a couple of those, which is very frustrating as a lawyer, because then you've done all this work and nothing comes public. But in terms of the overall system, that's, I think, better than having a ruling, an appeal, a compliance panel, what have you. I think most recently the China case filed against the EU on non-market economy. From what I read in the press, it seems the interim report came out and then China withdrew its appeal because it was kind of afraid to see this become public. So my thinking was that I completely agree with you, Simon. Right now it's useless. When you litigate, you're not going to throw your appeal arguments out there in the interim review stage before the panel. You'll save that for appeal. So now it's useless. I completely agree. But what we could see is, if there's no more appellate body for real, that the interim review becomes kind of an appeal mechanism to correct facts and perhaps to correct legal findings as well. But I I think it would be very useful to find a system that incentivizes parties to deal with as many issues as they have at the interim review stage, especially, I would guess, when it comes to factual mistakes, that those are raised there and not in the form of Article 11 claims before the appellate body.
Thank you. Let me distinguish here one thing, because I see a question from a point from Pablo Ventes that came up that said there are recent cases that were suspended after the interim report came out. So no, I agree that when parties see an interim report, they get a sense of, well, here's the outcome. Maybe I lost. Maybe I better go in and settle. What I wonder, though, is the interim review necessary for that? You could have a report circulated to the parties confidentially, and then they have time to decide if they want to settle. I'm just not sure whether the interim review process where parties submit comments and sometimes hold a hearing, whether that's worth the time and effort. But I do think that putting a report out there in confidential form is useful for the parties to sort of spur them to maybe settle. Does anyone else want to weigh in on the value of interim review and interim reports?
I just have one comment. I don't know if the interim review stage as it is right now, and if maybe I misunderstood you, Joost, would work in the way that Joost is sort of alluding to. Because it's not supposed to be an appeal process, right? It's supposed to be sort of a system where, the panel, gives its report and the parties have to comment on whatever. And of course, now that there's no appellate body, it's become a little bit more important because parties know that there's no other chance. So parties maybe would want to address the issues that would have rather, held back and addressed at appeal. But the problem is they're addressing this issue with the same panel that issued the original report. And there's probably would be a little bit of an inertia to change decisions at that stage. And so I don't know how valuable it would be to sort of, not to say relitigate or to sort of raise issues at that stage, because I don't know what the value would be. But obviously, if there's anybody that has, an inkling of how that could be used more valuably, in the light of the fact that the AB is not around, I'd be really interested to hear.
I think the fact that there is no AB puts an added gravitas on the panel process, and certainly those occupying that role of panelists understand the shift and the relative importance. People always say you're the best review or something to that effect because you're the last review. And I think that is now going to descend to the panelists who now understand that they're really going to have the final say in this matter. I think the incentive structure therefore changes slightly because I think this is the only time you get feedback from the parties. I think you want to get it right. You want to promote better outcomes for the parties, and that's your role at the end of the day. So I think there's a role for an interim process that kind of serves in this context anyway, in the present climate, as a way to get feedback directly from the parties and re-engage in the process, because you understand that, at the end of the day, there's no further, except if you are an MPIA member, but there's no further bite at the cherry. So I do think it changes the mindset of those occupied in the decision-making process.
Thank you, Genevieve. Johan, I think you have your hand raised.
Thanks, Simon. Just a quick comment. As you know, the interim review stage is a leftover basically from the GATT, a diplomatic sort of approach to find an agreement to the dispute and the parties to settle. But perhaps I'm just thinking now with the issue of the appellate body, perhaps it might be useful in the time when there's no appellate body to use the interim review stage a little bit as a hybrid, as a second bite at the cherry, sort of a review body. But I also get the point that it'll be difficult to have the same panel re-looking the same thing. Perhaps you can have the panel or one of the panelists, but with almost an assistant or somebody, a third party, an arbitrator or somebody to assist the parties and sort of to experiment a little bit with that until such time as the review body is properly functioning. Because I'm a little bit worried that if you, I also played around with the idea of beefing up the interim review stage, but it might be that parties might be incentivized to put everything then to the interim review stage and question everything, which you also don't want. But I think perhaps it's worthwhile to think a little bit how to use this opportunity to experiment. But of course, taking in Ignacio's warning, it might end in negotiations for taking decades.
Thank you, Johan. Let me raise this. This is a question that comes in from Wto Wu, and I mean, I think I've heard the point from some lawyers even in the system who say we've gotten too litigious, and we're just spending too much time on litigation, and it's taking us away from negotiated solutions. And so let me ask for any of you with your varied experience in this. There are other mechanisms to resolve disputes in the DSU. There are good offices, conciliation, mediation, arbitration, but they are rarely used. And so I guess my question for anyone who wants to answer is, why is that? And is there a way to send some of our litigation over to these non-litigation possibilities? Anyone have any thoughts on that?
Well, I'd like to make a comment as to the why. I don't think members are keen to be the guinea pig. And I think it might take, maybe a bigger, a more frequent user to give some sort of legitimacy to that process. Because members have really bought into this, getting an outcome, getting a decision, making sure that it's an enforceable decision. And so maybe there might be some doubts about whether these, disputes can be mediated. And of course, not every dispute can be mediated or conciliated, because some disputes are very highly political in nature. So I agree. I'm a very big proponent of trying to resolve some disputes in a non-litigious way, especially regional disputes that we've seen a lot, in the recent few years. And I don't know how it's going to change, and maybe there needs to be some sort of a person, a big member that uses the system. But yes, as of now, yeah.
I think just to add to that, actually, that I do think it's treated as a poor cousin. But again, with the whole shift in emphasis from a very highly formalized system of dispute settlement where you have the appellate body, now that that's no longer there, one way of thinking about it is that the panel system becomes one of many other types of processes that you can engage without, having any similar kind of rank, because the appellate body gave dispute settlement in some ways more of a rule-based kind of hard law orientation to dispute settlement. And the other thing that I think we have to be careful about is not so much that doesn't serve as an alternative, meaning these ADRs, the mediation and conciliation, but that members begin to look outside of the WTO as possible areas in which they can bring disputes. I mean, we're having increased cases of panels outside of the WTO in the context of FTAs. And I think one of the possible kind of consequences, instead of redirecting members to other types of non-litigious dispute settlement regimes, is to go outside of the WTO and just look to find solutions outside of the context of WTO dispute settlement. I think that's a real risk, provided obviously that this is a means in which you can settle a dispute, assuming that the panel would have jurisdiction over the two parties. But I think an increasing number of FTAs will give many more options outside of the WTO process that we have to be really keyed or look at very keenly.
Let me turn, unless someone else wants to weigh in on that, let me turn to another point. So I am completely on board with the efficiency goals that we have here, and let's shorten this up, and it's taking too long, the reports are too long. But I just to play devil's advocate, Julian Arado raises this point that perhaps we're overemphasizing efficiency reforms. And so, in Jost's, one of his 10 suggestions, he says, stick to the DSU Appendix 3 timeframes unless exceptionally compelling reasons not to. but I wonder if we're putting too much emphasis on these Appendix 3 timeframes. I mean, these were developed in a different era with much less jurisprudence to deal with parties who handled disputes differently. So maybe we've created unrealistic expectations, and instead of saying, we need to go back to where we were, we need to do everything we can to get there, maybe we need to sort of just take a broader look at what the system requires. And I think Yoast is doing that, but I wonder if we're trying to push too hard in the other direction. And I don't actually think we are, but just to play devil's advocate, I mean, are we too obsessed with these Appendix 3 timeframes and short, quick disputes, when really what we want is a process that's, sort of more broadly speaking, we want a process that satisfies the members, that comes up with correct results, that gets us to implementation in as much as possible. So are any or all of us going too far with efficiency? Does anyone have any second thoughts about pushing so far in this direction? Yes.
Yeah. So it's actually a question I also asked: are the time limits that countries agreed to in the 90s, are they kind of outdated, what have you? But then if you look at preferential trade agreements, RCEP, CPTPP, all of these preferential trade agreements, they reiterate the importance of these strict timeframes. If anything, they shorten them further, right? Now, I think, but Ignacio knows this better than I do. I think what may be going on here is that on the one hand, you have the negotiators, those who see the big picture and set up the system, who really value the importance of time. But then you have the litigators, the law firms. I mean, and if you litigate, as Simon was saying, you want to go to the bottom of this. You want to win. You want to throw out all of the claims out there. So it's not surprising that for specific cases, there's always a pressure to take more time. And as Jean-Yves was saying, if you don't have strong panelists who know how to manage a case, the risk is that they just sit back and let the parties play out their tricks. And then you have a secretariat who, if anything, may further lengthen the procedure by asking questions that do not narrow the dispute, but kind of go on a fishing expedition where you have hundreds of questions. It's not unique to have hundreds of questions to a panel, which, unlike what Johan was saying, it's not narrowing down the issues to the core, it's broadening them. And so I think there's a bit of that tension going on. The negotiators who see the goal of settlement, preserving the trade deal, and then the litigators who may have different incentives, even though they are both from the EU Commission or both from the USTR or what have you.
Ignacio, I think you wanted to weigh in.
No, I would just like to say that, I mean, obviously you always need to keep a balance between timeliness and effectiveness, and you certainly would not want to have, as a result, panel reports which are clearly lacking in the necessary quality. But I would tend to think that it is right at this point in time to put very much the emphasis on the need to deliver on the timelines that are reflected in the DSU. For the reasons that Josh explained in the beginning, I think it's part of the important legitimacy of the process to be able to deliver it within certain timeframes. But that's only going to be possible if you really have a fundamental change of approach to how cases are decided. And that's what I really emphasize, the real important cultural change that this principle of judicial economy is not only for the appellate body, I would say even more for the panel phase. And then it also comes down to the question about how to ensure that you have the panelists that can do this work within those time frames. I mean, I take the points of Johan's about the difficulties of a formal selection procedure. I mean, I very much understand why people don't want to have twice the process of selection of members of the appellate body. But that's what I think we should really be reflecting about, more pragmatic ways of trying to be sure that one can establish a roster of panelists which are well experienced, we have time to dedicate themselves for the cases, and which are available for the parties if the parties consider that this is the way that they want to solve the dispute. You don't need to have a formal decision in the DSP. You have different ways in which this can be done. I would have to say that in my view, and I'm not saying that because Jos is here, the parties to the MPIA did an excellent job in selecting a group of MPIA arbitrators in a rather short period of time.
Thank you, Ignacio. So I think it's clear that we could talk about this all day. We would all enjoy doing so, but we have to wrap it up. Let me say thanks to all the great speakers. I really enjoyed listening to everybody's insights. Thanks to the ASIL and the IIEL. And let me now turn it over to David Kleiman for some concluding remarks.
Well, thank you, sir. Thank you so much, Simon. Great moderation. Many thanks for doing this today. I must say that it's been an absolute joy to watching this discussion just now, and I'm trust that I'm not alone with this feeling. It's been very, very technical, of course, and which is sort of the nature of any discussion looking at the WTO panels. But we will turn to some of the more juicy legal, political questions in what is hopefully our next discussion on rethinking the WTO appellate body review. What we wanted to achieve today really is to generate a debate on one of the most pressing and perhaps most neglected questions of international economic legal practice that appeals to academics, practitioners, and policymakers likewise. And I'm certainly biased with this, but I'll go out on a limb here and call that a mission accomplished. For that, we are, of course, first and foremost indebted to you, the moderator, Simon, and the panelists who kindly agreed to come together today to enrich us with their knowledge and perspectives. But as with every project, there has been a lot of people also working involved and working behind the scenes and who didn't make it into the spotlight. And before you go back to your busy work schedules, please just allow me briefly to give credit where credit is due. As for our friends from the ASIL, IEL interest group, they deserve much of our gratitude as they welcomed us with open arms when I approached them with the idea for this panel. Thank you very much, Kathleen Clausen and Julie Nerato. We look forward to working with you on similar projects in the future, and there's already one we have in mind, and I hope it will come together. As for Georgetown's IIEL, my host institute, I would like to thank Executive Director Marie Kasparek and her team member Miha Jain, who made this happen in lightning speed on an extremely short notice. And last but not least, Chris Brummer, the IIEL director, who nurtures a working environment where initiatives like this one can flourish, and this should never be taken for granted. If you liked what you just saw, I'm sure you will also value much of the forthcoming IIEL programming on trade and investment. In March, for instance, the IIEL will host the Global Trade Academy for practitioners and academics. And then there will be the G2 conference in early summer, and we will certainly love to see you there too. Two last housekeeping items. Bear with me for a few more seconds. We are, of course, aware that not all of the 500 registered participants were able to join us today, and there might be interest in this discussion beyond those participants even. But we have, of course, recorded this event and will post it online as soon as it is available. Please also do not hesitate to send us your feedback. We value and rely on your critique just as much as on your compliments. And with that, I'm afraid we have arrived at the end of our program today. Thank you so much for joining us, and stay safe and keep well.